Okay, thank you, John. The first bill we're going to hear is Senator Louis Lucas's bill. It is a recommendation, I believe, of the Crime Commission. Senator Lucas, pretrial data collection. Senator Lucas, Senate Bill 1391.
Yes, sir. Bye for the day.
Okay, okay. Good morning.
Senate Bill 1391 is a bill that was unanimously recommended by the Crime Commission. The Crime Commission and numerous other agencies from all three branches of government have been working to collect and analyze data on Virginia's pretrial process for the last few years. 7 local and state agencies contributed to the data collection. A total of 10 databases were merged to make the pretrial database, which tracks defendants from their initial charges to the final disposition of their case. And Mr. President, there's a substitute.
Motion to adopt substitute has been moved and seconded. All in favor say aye.
Aye.
All opposed, no. Motion carries.
Mr. Chairman, the bill codifies and continues the work of this project, tracking statewide and locality level pretrial data. And of course, that's imperative to understanding Virginia's pretrial system. The substitute bill, Mr. Chairman, amends the language in the enactment clause to require the Sentencing Commission to make the database from this project publicly available by October 1st, 2021, and on data dashboards by December 1, 2022, because more time is needed to set up the dashboard. It amends the Government Data Collection and Dissemination Practices Act to add Sentencing Commission to the list of exempted agencies. And of course, this is necessary to limit access to personal information. And with that, Mr. Chairman, if there are no questions, I move that the bill be reported.
Is there a second? Senator Dees moves, seconds. It's been moved and seconded that Senate Bill 1391 of Senator Lucas be reported. All in favor, vote aye. Yeah, sorry. Okay, all right. It's been moved and
Members of the
seconded.
public. There are members of the public that have their hand raised.
Okay, all right. Anybody from the public like to say something? Anybody from the public would like to say a word?
Maisie Osteen, please go ahead.
Go ahead.
Good morning, Maisie Osteen. I'm from the Legal Aid Justice Center, and I speak on behalf of the Pretrial Justice Coalition and very much support Senate Bill 1391 and thank Senator Lucas for carrying the torch forward.
Okay, thank you. Is there anybody else from the public?
Jessica Sapilo.
Jessica? Jessica
Yes.
Sapila? Okay, go ahead.
Yeah, thank you. I'm with the Williamsburg James City Court Watch program, and thank you for carrying this forward. And wanted to say that statewide data collection is critical to better understanding racial and economic disparities that exist in our justice system. National studies show huge disparities in who gets held pre-trial. And in Virginia, Court Watch programs have observed the same trends. For example, our Court Watch observers have seen 65% of Black defendants are held without bail versus only 39% of white defendants. Conversely, more than 40% of white people were released on an unsecured bond, but only 22% of Black people were offered this type of release. So it is important that we have a system to collect this statewide data so that we can better understand and address these disparities. So I ask that you support this data collection legislation. Thank you.
Okay,
Thank you.
Dominique Martin, please go ahead.
Go ahead, Dominique Martin.
Good afternoon, Mr. Chair, members of the committee. My name is Dominique Martin, Policy Research Analyst, New Virginia Majority. And I'd just like to echo the sentiments of the previous speakers. Can you hear me, Mr. Chair?
Go ahead, very quickly. 30 seconds.
Yes,
30 seconds.
Yep, just like to echo the sentiments of the previous speakers. I'm also speaking on behalf of our Court Watch team that was initiated in Chesterfield, Virginia. So we do hope that you support this legislation and push forward.
Okay.
Thank you.
Is anybody else insist on saying something? If so, just say your name and whether you're in favor or against. Anybody else?
Good morning, Mr. Chair. This is Brad Lindsay with Justice for Virginia. We also support this legislation.
Okay. Thank you. Anybody else?
Sean Mineta with the Humanization Project. We also support this legislation.
All right, thank you. We have a motion. Go ahead, next. Very quickly.
Good
Good morning, Lakeisha Cook, Virginia Interfaith. We strongly support this bill.
Okay, is anybody opposed to the bill? All right, we have a motion on the floor that the substitute be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, vote no. Central Lucas wants to vote. Okay. Okay. Thank you very much. That bill's been reported and substitute's been reported and re-referred to finance. Now I'd like to report that Senate Bill 1113 of Senator Sproul will go by for the day. That's Senate Bill 1113 of Senator Sproul will go by for the day. In addition, Senate Bill 1264 of Senator Morsi, Senate Bill 1264 of Senator Morsi will go by for the day. Now I'd like to call on Senator Deeds. He has a couple of bills. Senate Bill 1248.
Two bills. 1248 is a recommendation of the Committee on District Courts. It simply requires that the appointed evaluator of a juvenile acknowledge receipt of the court's order for competency evaluation. There's an existing requirement for acknowledgement for adult evaluators. The change would create a record of when the order is received and help prevent the order and associated evaluation from being overlooked and not completed. I'd move to report.
Okay. Is there any discussion, any questions? Sorry, it's been
Mr. Chair, I believe there's a amendment to this bill.
Okay. Would you like to
And the
report?
amendment is on line 50 after order. It would insert if appointed evaluator or the director of the Community Services Board, Behavioral Health Authority, hospital, or private evaluator is unavailable to conduct the evaluation, he shall inform the court on the acknowledgement form. And this is basically just a technical.
I move the amendment.
Okay.
Second Cree's
It's
motion.
been moved and seconded that the amendment be adopted. All in favor say aye.
Aye.
Aye. All opposed, no. Motion carries.
Now move to report as amended.
Okay. It's been moved and seconded that the bill as amended be reported. Any discussion? Oh, is there any public comment? I'm sorry. Any public comment at all? Apparently not.
There's
Okay.
no one with their hand raised. Oh,
Okay.
there's one person.
Is there-
Christy Wright.
Christy, you want to say something from the Supreme Court?
Christy Wright, you have the floor.
I'm certain she's for the bill. She's probably there to answer technical questions.
I am. I'm just here for questions.
Okay.
I have no comment. Thank you.
Okay, thank you very much. Been moved and seconded that the bill as amended, Senate Bill 1248, be reported. All in favor vote aye. All opposed vote no.
Ayes 14, no 0.
Okay, ayes 14, no 0. The bill is reported. Senate Bill 1250, again, Senator Deeds' bill.
Okay, 1250 is a little more complicated, and it has some cost associated with it, so I expect it will need to go to the Finance Committee if this committee chooses to report it. This bill is pretty simple, but it's not all that simple. It requires the background check when you're renting a firearm. This bill arose to me. A couple of families contacted my office. They're families who lost sons, young men, this past year within about 30 days of each other. I think they both walked in, and they both had some problems, some mental health problems. They both walked into a firearm range in Senator McDougal's district. They rented a firearm. They didn't have to do a background check, and they took their lives. Both of them did. So this bill would require a state background check. We can't require a federal background check because it's my understanding federal law does not allow that when a firearm's rented. But that's simply what this bill does. It requires a background check be done when a state background check be done when a firearm's rented.
All right, is there any discussion? Any questions of the patron?
Mr. Chairman.
Yeah, Senator Serval.
Thank you, Mr. Chairman. So, I don't, and this might not be for the patron, it might be more for the state police, but can somebody highlight for me whether or not this, whatever this check that would be done would also include a check of the do not sell registry that we passed last session, which goes live on July 1?
It would be a check, Mr. Chair, it would be a check of whatever the state records are. State criminal history, state mental health checks. Any, I don't know about the do not sell list, but
Mr. Chairman.
Senator Serval.
Thank you, Mr. Chairman. When I read the text of the bill, it says they're only checking the CCRE and the national background check system, and I don't believe the do not sell registry is part of the CCRE or the national instant background check system, and so that's why I was asking.
Mr. Chairman, Charles here. To answer Senator Serval's question, I do believe that we put the do not voluntary list in the CCRE. While it's not a criminal record, it is in the context of the CCRE, and the background check that's to be done checks to make sure that anyone is not prohibited from possessing a firearm, which should include a check of the voluntary list.
Mr. Chair.
Yeah, okay. Senator Serval, is that it?
Peterson.
Senator Peterson. You look so much alike. Go ahead.
I guess maybe this is a question either for Senator Deeds or maybe more appropriately for staff. A lot of us have gone to resorts or places where they have skeet ranges or trap ranges, and you arrange to go shooting. And it's either part of your hotel experience or maybe you pay a few bucks extra. I know the Democratic Caucus has gone to a certain resort in Western Virginia for pretty much every year since I've been in this business, and every year people do the shooting range. How do you handle that? Are you going to give every single person a criminal background check if they use a shooting range at a resort?
Mr. Chair, I don't think there's any exemption in here for a resort. The concern in this situation is neither of these young men would have been able to buy a weapon because of their mental health backgrounds. But they were able to rent a weapon, and they were able to end their lives. There's not been a whole lot of research done on suicide, but the research suggests that people have a plan. People that are intent on committing suicide develop a plan for doing it, and anything you do to interrupt that plan may end up saving that person's life.
Mr. Chair, just to the patron, did I understand your scenario, Senator Deeds, to mean that these two people went to a gun range, rented the gun, when they got the gun and the ammunition, that they took their lives right there on the gun range?
They took their lives right on the gun range, and honestly, this is not something that just happens in Senator McDougal's district. There was a death last week, I think, in Loudoun County at a gun range. I don't know anything about the circumstances of that, but in this situation, these young men took the gun, went into the wherever it is they shoot inside a gun range, and ended their lives in there.
One final question, Mr. Chairman. Would this mechanism allow for when they went to rent the gun, would they do the instant background check right then, and would that have captured? Had the gun store done the background check, would that have captured the information necessary to have prevented the two young men from getting the gun?
Mr. Chair, Senator Morrissey, that's a very good question. I think Senator McDougal will tell you that at least in the instance of one of these young men, it would not have captured because you would have had to have access to the federal background information. What this will do is will allow access to the information gathered by the state. And as I said, my intent here as much as requiring a background check for the purchase of or for the rent of firearm is to try to impede someone's decision to end their lives. And the research that I've seen suggests that anything you do to interfere with that, anything you do to slow that down, that plan down, gives you a better chance of saving that person's life.
Mr. Chairman.
Thank you, Mr. Chair.
Mr. Chairman, McDougall, just to answer Senator Morrissey's question, I know the one family, I think both families have been in contact with Senator Deeds. One family has been in contact with me, and I think the last conversation I had with them, that the state background might have captured that information. But it is certainly, I took a different approach than putting, Senator Deeds and I have discussed this on probably more than he would prefer us to have discussed this. I took a different approach and put in a budget amendment to have the state police review the database and what the interplay with the federal database is. I do know that the state police is undergoing some IT changes with their database over the next 24 months, and they can speak more directly to what impacts that this will have. But I think Senator Deeds went the bill direction. I went with the budget amendment for state police to come back with a study of how it could interplay together, what we could do with the federal government and our current database.
Yes, thank you,
Mr.
Mr.
Peak.
My question kind of follows what Senator McDougall, and this was a question to the patron, is was the state police database equipped to handle this?
Mr. Chair, Senator Peak, the question, I think the state police say that they're going to need to do some retooling if this is part of the statute. That's why I think this bill will end up having to go to finance if we approve it in here. But it doesn't seem to me like it would be a huge reach for them to be able to add this to what they're already doing. What they can't do is access the information that is available in the federal system, and that's something beyond our reach as state legislators.
Okay, anybody from the members of the public would like to speak? I think there are a number of them. Who would like to go first? In favor? All in favor? Speak first. Nobody's raised their hand. Yeah.
This is Lori Haas.
Yeah, Lori Haas.
Good morning. This is Lori Haas. I'm with the Coalition to Stop Gun Violence and the Educational Fund to Stop Gun Violence. We thoroughly support the bill. The Virginia State Police run the Virginia Firearms Transaction Program. It is a robust background check system that the Virginia State Police founded in 1989. It predates the FBI NICS system. The FBI actually came to Virginia to learn how to set up their NICS system. Prohibitors from certain Virginia criminal convictions, mental health adjudications, protective orders, and other prohibitors of persons purchasing or possessing firearms are in the Virginia databases. Those systems work, and they work well. From news reports, and I did not speak to these families, these young men both were prohibited through mental health adjudications in the courts. That's a prohibitor, and they would have been prohibited from accessing a firearm had they tried to purchase one. Sadly, in these circumstances, they went to arrange to rent one to end their lives. We know that suicide by firearm is deadly most of the time, whereas other suicide attempts by other means are not. The recidivism rate for suicide is very, very low, i.e. if you survive a suicide attempt, the likelihood is you're not going to go on. And let's think about the safety aspect of this. The Virginia Firearms Transaction Program returns a denial or approval in moments, mere minutes. That is a small price to pay when saving lives. It's a very small price to pay. For those persons who are prohibited, it could be saving lives. We strongly support this bill. The Virginia State Police are quite capable of doing this. Their system is thorough and robust. and easy to access. And we strongly urge the body to support this bill.
Okay, thank you. Andrew Goddard.
Mr. Goddard, before you speak, can we please have those who would speak in favor of the bill raise their hand in Zoom?
Yeah, go ahead, Mr. Goddard.
Mr. Chairman, thank you very much. Virginia Center, Andrew Goddard, Virginia Center for Public Safety. We support the bill. Suicide by rental gun in a range is fairly rare, but it is an issue that's happening all over the country. And our background check system, if it puts a slight impediment to that, it's going to save some lives. Okay. And I would suggest that anyone who needs to rent a gun, because guns are so readily available to purchase, if they need to rent a gun to do this, the chances are much higher that they were a prohibited person, because otherwise they could go and buy their own gun and do it in the comfort of their own home. Okay. So we support this bill.
Thank you. Who else in favor? Raise your hand for favor. Tanya, is that your name? I can't read it.
Yes, thank you. Yeah, good morning, Chairman and members of the committee. I'm Tanya Sharp from the Beatty Campaign to Prevent Gun Violence. We certainly understand that comprehensive background checks are key to keeping firearms out of the hands of those who are likely to harm themselves or others. This is true. This is just as true for rentals as it is for sales. Okay. There have been too many cases of those who rent firearms at gun ranges harming themselves, and actually there are a lot of instances where they harm others as well. It's prudent and responsible to take the extra step to prevent injury and death. For these reasons, we strongly support the bill.
Okay. Who else in favor? 30 seconds. Raise your hand, Emmanuel.
My name is Emmanuel Harris from the Black Coalition of Change. As a clergy of 30 years, we strongly support this bill to save lives and dealing with people who are suicidal and mental.
Okay, thank you. Kelly, you have your hand up in favor. 30 seconds. Kelly?
Thank you very much. My name is Kelly Roscom. I'm with the Educational Fund to Stop Gun Violence. We strongly support this bill, particularly in light of the hard work that this legislature did last session to address suicide by firearms, particularly the voluntary do not sell list, as well as the substantial risk order bill. It would be a shame, in our opinion, to leave this gaping loophole to allow individuals access to firearms. Thank you very much.
Okay, thank you. 30 seconds. Anybody else in favor? Raise your hand if you're in favor. All right, anybody? Yeah, okay, Bradley, Carroll, 30 seconds, please.
Thank you, Mr. Chairman. My son was one of the ones that committed suicide last July in July of 2020. I strongly support this bill. The opposition will tell you that, they acknowledge the issue, but offers no solutions. Over the course of 5 minutes, my son turned an assault rifle on himself 4 times. No one at the facility noticed. This is why we can't leave the resolution of this issue to the opposition, and this is why the law must change.
Okay, thank you very much. All right, everybody who want to speak in favor has already spoken. People who want to speak against, 30 seconds, please. Raise your hand, 30 seconds. Against.
Vic Nichols.
Vic Nichols, go ahead.
All right, we've had 2 examples out of how many thousands or millions of gun rented. How long does this take? Can take days. Why are out-of-state gun control advocates trying to dictate laws proven that they don't work against people misusing guns and only infringe on the Second Amendment rights of the others and also adversely impact minorities? If they want to put in laws that work, go down to Pistol City and tell us how to do that. But stop infringing on the rights of others when you've only got 2 examples to hold on it.
Okay.
Thank you.
Thank you. Who else is against it? 30 seconds. Anybody else against it? Okay, David, 30 seconds.
Trevor Santos with the National Shooting Sports Foundation, speaking in opposition to Senate Bill 1250. For several years, we've undertaken a voluntary awareness program in conjunction with the American Foundation for Suicide Prevention. We've developed a toolkit to help make firearms retailers and ranges aware of how we can do our part to prevent suicide. I do want to point out the issue with the background check system. Normally, when you do a firearm transfer, it would go through the NIC system. However, because a rental does not constitute a transfer per federal law, this transfer would have to go through the Virginia State Police, which would only allow them to ping their databases, which would be an incomprehensive list of any of the prohibiting factors and any of the prohibited persons. So if you were mentally adjudicated in another state or prohibited, had a prohibiting factor in another state, this would not be included. There are a number more reasons in a letter you all should have received. For that reason, we oppose
Thank you.
SB 1250.
Anybody else insist on
Mr. Chairman,
speaking against
Mr. Chairman.
Who's this?
Yes, sir.
Yes,
Mr. Chairman.
BJ Spiker, right?
Yes, sir. Thank you, Mr. Chairman. DJ Spiker, National Rifle Association. Your office should have received a Harvard study published last April. This is specific to suicides at gun ranges. They concluded these are exceptionally rare. It's 35 nationally, and it's best left to ranges and Virginia State Police to come up with in-house policies to regulate this. This bill would not be a preventative measure. And currently, Senator Peake, you asked about the workload. Currently, state police are reporting a 42% delay rate in the background check system. It cannot handle this workload. The current workload, 42% delays, this absolutely would impact ranges and their business models. Last year, this committee and this body promoted safe, responsible gun ownership. This would discourage hands-on training. It would hurt the opportunity for individuals to get their hands on and have experience and have safe training. We support.
Thank you
sir.
very much. Is anybody else insist?
Chairman.
David
Adams, Virginia Sports Association.
David Adams, go ahead. 30 seconds, please.
Thank you, Mr. Chairman. With the Virginia Shooting Sports Association, we're the state affiliate of the NRA. We just echo the comments of Mr. Spiker and Mr. Santos, and we oppose the bill.
Okay, thank you. Now, is there a motion?
Mr. Chairman.
Who's this?
William Barrett from Arlington.
Okay.
I wanted to point out that the
30 seconds, please.
Mr. Chairman. Yes, thank you.
Go ahead.
This bill is trying to have it both ways. You know, if you look over to the House of Delegates, Delegate Lopez has a bill that's saying that the state police need not only the 3 days they already allowed, but 5 days to be allowed to process background checks. So clearly, this is just going to add to their backlog, as Mr. Spiker said. This will make it harder to get access to training. And I think Mr. Goddard questioned why someone would rent a gun. Well, that could be because maybe you can't afford hundreds or thousands of dollars for a particular gun. You just want to try it out.
Okay, fine.
It already
Thank
takes
you.
Mr.
Chairman.
quite a while to get out to a range that's close enough.
We have a motion.
Mr. Chairman.
Yeah, who's this?
Mr. Chairman, over here.
Yeah, Senator Stewart.
Mr. Chairman, I've listened to the advocates on both sides of this, and I understand this is a horribly tragic situation that happened. And I think it's worthy of looking into, but the practicalities of the proposed bill, it seems to me it would nearly be impossible. So it seems this might be a good bill to refer to the Deeds Commission and have it studied and try to figure out if this is the best way to go about it or if there's another way to go about it. But I see the practical difficulties in having a bill like this go forward. So I'm not sure that Senator Saslaw's motion was seconded.
Yeah,
was it?
Senator Saslaw's motion was seconded.
Then, Mr. Chairman, I'd make a substitute motion that the bill be referred to the Deeds Commission.
It's been moved and seconded that the bill, substitute motion, the bill be referred to the Deeds Commission. Are you ready to vote on the substitute motion?
Madam.
Yes, Senator Deeds.
Mr. Chair, point of order. Is that an appropriate motion? I thought the only motions at this point in this session were to either report and refer, report, or PBI.
I think we can refer it to a commission.
Mr. Chairman.
Let's have a 20-minute discussion on that.
Yeah. We got a motion before us, a substitute motion to refer to the Deeds Commission. Is there any discussion on this? If not, okay. All in favor of the substitute motion to refer to the Deeds Commission, vote aye. All opposed, no.
Ayes 7, noes 8.
Okay, the motion fails. The motion is now before us to report the bill. Moved and seconded to report the bill.
Finance wanted this.
And to send and refer to finance. I'm sorry. Report and re-refer to finance. All in favor of the motion to report and re-refer to finance, vote aye. All opposed, vote no.
Ayes 10, noes 4, 1 abstention.
Okay, the bill 1250 has been reported and re-referred to finance. Okay, the next bill, Senator Boysko has a bill 1226, compensation
Mr.
board.
Chairman?
Yes.
You have Senator Pillion, who's not on the committee, that's sitting out in the hallway.
Yeah, no. Okay, we'll do Senator Pillion. Okay, I was looking for him. All right, Senator Pillion, Senate Bill 1400, Board of Wildlife Resources, quit claim and conveyance of easement, Tazewell County. Bill for Tazewell County, where my grandmother was born. Got relatives down there. Okay, Senator Pillion.
Thank you, Mr. Chairman. You basically explained the bill. This bill is brought on behalf of Senator Chafin. He'd been working on it the past year with Wildlife Resources in the Attorney General's office. This piece of property was surveyed wrong, so it's just a quick claim and conveyance of that 13 acres back to the Valerie McDowell Trust,
Okay.
which is the rightful owner.
Okay. Is there any discussion?
Move to report.
All right, it's been moved and seconded that Senate Bill 1400 of Senator Pillion's be reported. All in favor of the motion, vote aye. All opposed, no. Ayes 15, yeah. Thank you, Senator. Okay, Senator Boysko, would you like to have your bill heard now? Senate
Yes.
Bill 1226.
Thank you, Mr. Chairman. I'm bringing 1226 on behalf of Fairfax County Government. SB 1226 would provide that the Compensation Board shall consider workload totals comprehensively, including the use of diversion programs, and specialty dockets when determining staffing and funding levels for an attorney in the Commonwealth and in the office. Over the past few years, we in the General Assembly have taken enormous measures to reform the criminal justice system, and we've made a lot of progress, but of course, you know, we still have some work to do. One of these areas that we're seeing positive results is in the diversion programs. This holds people accountable for their behavior without resorting to legal sanctions and court oversight when possible. Such programs may allow young people to mature into adulthood without being thrown off track by negative effects of a criminal record, and potentially damaging their future opportunities for employment and higher education. Another critical area is in mental health. We've spent an enormous amount of time discussing the impact of the mental health crises and police incidents during the recent special session. Individuals with mental illness, developmental disabilities, or co-occurring substance use disorders sometimes find themselves in the judicial system at a time when they need most help is from a behavioral health specialist. To address this need, a mental health docket was approved in the Virginia Supreme Court for Fairfax County in 2018, and the docket allows the Commonwealth and defense attorneys to require a defendant to complete different phases of treatment and graduate before the defendant's charges will be resolved. Fairfax County's most recent assessment of their Diversion First program reports that nearly 1,700 people with mental illness, developmental disabilities, or co-occurring substance use disorders have been diverted from potential arrest. This program helps people who are in crisis recover and to take control of their lives. And it seems like exactly the kind of outcome we in the General Assembly have been seeking to encourage. Unfortunately, our funding formulas in the state do not recognize this new approach. The current formula relies primarily on felony indictments and sentences as a basis for gauging workloads to determine the allocation of state staffing and funding resources for each Commonwealth Attorney's Office. SB 1226 would update the state's outdated formula for funding the Commonwealth's attorney's offices by requiring the Compensation Board to take a more comprehensive approach to evaluating the workload of Commonwealth's attorney's offices when determining staffing and funding levels. I'm carrying the bill at the request of Fairfax County. I have the Assistant Attorney Chris Sigler and the Commonwealth's Attorney Steve Descano here to support the bill and answer any questions. And I hope it is the pleasure of the committee to pass the bill on to the Senate Finance Committee for further consideration.
Any questions of the committee to the patron?
Mr. Chairman.
Senator Sorrell.
Last session, Senator Morrissey carried a bill that directed the Compensation Board to redo their formula, because right now they only determine the Commonwealth attorney staffing based on the number of felonies indicted and the number of people convicted of felonies. which from my perspective is completely, it's not a very holistic way to incentivize our Commonwealth attorneys. We referred it to a study. It's my understanding that a bunch of Commonwealth attorneys met to try and come up with a better funding formula. And basically all the ones that benefit from the existing system didn't like it, and all the ones that wanted to change things tried to change it, and it got absolutely nowhere. And so given that they're not going to move, it's pretty clear to me that we need to do something to get them to move. And I have a budget amendment which is similar to this, and this proposal needs to move forward so we have a fair system. So I would move that we report the bill.
Is there anybody on the committee who would have any further questions of the patron?
Mr. Chairman.
If not, yes, Senator Morrissey.
Thank you, Mr. Chairman. Following up on Senator Serval's comment, last year, remember when I broached this subject, you sent a letter to the Commonwealth attorneys requesting that, and at their request, you did that. Have we heard back from them pursuant to the letter that you sent and the request that they made?
I'm not aware of any response. Right now, anybody else have any questions of the patron? All right, members of the public, some would like to say something. I see Colin Stolley, I think I've heard that name somewhere, is sitting out there ready to speak. Would you like to say?
Yes, Mr. Chairman.
Go ahead, Colin Stolley.
Thank you, Mr. Chairman. Colin Stolley, Commonwealth Attorney in Virginia Beach. I'm also the president of the Virginia Association of Commonwealth Attorneys. If I could speak to Senator Morrissey's question, and last year, Senator Morrissey introduced a bill to change what our staffing standards are. We went to Senator Morrissey, and he was kind enough to work with us on that. And we did form a work group that encompassed all kinds of representatives from the Commonwealth Attorneys Association. We worked very hard over this year to come up with new staffing standards. And Senator Serval, I would say that there is no one that is opposed to changing our staffing standards. I'm not sure where that information came from, but this work group is very much looking to change our staffing standards. And we want to ensure that we do get credit for diversionary programs like drug court, mental health dockets, that sort of thing. But what became very clear in this work group that we worked hand in hand with the comp board on is that it was not possible to put a value on that time, to give credit for that time involved without there being some sort of time study. And if you take a look at the fiscal impact statement associated with this bill, that's exactly what this is trying to address. No one in VACA is opposing the idea that the comp board take into considerations alternative sentencings and diversionary programs. We're all in favor of that. The problem is at this point, we don't have the ability to put a value on that time to allow for the compensation. So what we need to do is a time study. And Senator Edwards, VACA did send a letter explaining this, and Senator Morrissey, we did send a copy to you as well. We broke this into two parts. We tried to address initially the concern of Commonwealth attorneys being funded based on number of charges. And I will say it's been said a couple of times so far that we're funded based on indictments. That is not accurate. Our funding was based on sentencing events at the circuit court level, and that could be one charge or 5 charges. It didn't matter how many charges the defendant had, it was sentencing events. However, we wanted to move away from sentencing events because we understood that there were many in the General Assembly that had concerns with that. And so we worked with the comp board to move to a funding that would involve police arrest data, state police data, as well as population, and to form a new formula in the short term so that there is no ties between Commonwealth attorneys' funding in sentencing events. But that was all we could do without a time study. What the fiscal impact statement is trying to address is that we would bring in an independent party, the National Center for State Courts, to come in and do a time study of all Commonwealth's attorneys around the state. That will allow us to encompass everything that I think everyone is expressing here today, that Commonwealth's attorneys do that don't get credit for it, that don't get funding, like mental health dockets, drug courts, veterans courts. But until we get that time study, there's no way for the comp board to be able to compensate offices for those things. In Virginia Beach, we have a drug court, and it's not just an attorney that I devote to it, but our drug court wouldn't function if I hadn't taken one of my paralegals and converted them into the drug court administrator. So there's all kinds of different things other than just the number of people in drug court that offices do for diversion programs that without a time study, we simply won't be able to address that.
All right, thank you very much. You're in favor of the bill?
I am in favor of the time study associated with the bill. I'd always prefer for our staffing standards not to be codified, but if this bill allows for us to get the time study done, then yes.
Okay,
Mr. Chairman.
Thank you, Senator. Chris Sigler. Is that right?
That's correct, Mr. Chairman. Thank you so much. I'm Chris Sigler with Fairfax County. First of all, I want to thank Senator Boysko for carrying this bill for Fairfax County. I heard everything Mr. Stolle just said, and I'll just say that there's some frustration from places like Fairfax County about this compensation board formula, and I think rightly so, because it's so out of date. And you know, the General Assembly has spent a lot of work in the criminal justice area recently, trying to reform our criminal justice system. And right now we have a compensation board formula that funds Commonwealth attorneys for this court activity, like Mr. Stolle said, but doesn't compensate them for things like diversion programs and specialty dockets.
So
I think
you support the bill.
Absolutely, we support the bill because we think that you're going to only encourage people to use these diversionary programs if you pay them for it. If you don't pay them for it, then they're not going to use it. So
Thank
we
you.
100% support the bill and hope that it's supported.
It's been moved and seconded that the bill be reported and re-referred to finance. Is that right? Any further discussion? All in favor of the motion to report the bill and re-refer to finance, vote aye.
Ayes 15, no 0.
Okay, thank you all very much. The motion carries. Senator Barker's here, Senate Bill 1206, dealing with confidentiality of juvenile court records with exceptions. Senator Barker.
Thank you, Mr. Chair and members of the committee for the opportunity to present this morning on this. I think we have a substitute for this. Is
there a motion to adopt the substitute? It's been moved, and Senator D seconds to adopt the substitute. All in favor of the motion say aye. Aye. All opposed, no. Motion carries. All right, Senator Barker.
All right, I'll just briefly go over the situation that we're trying to deal with this Senate Bill 1206. There are a large number of adolescents, basically, minors, who are dealing with issues at the court system, including through the Department of Juvenile Justice Services, and also end up in situations where they're being also dealt with through the human services system, and particularly mental health services and those types of things where they're providing services there. What the intent here is to sort of bring the two together and be able to have information being shared between the court system and the judicial system and the human services system. This has been this bill was brought by people in Alexandria who said there's often been people in both entities dealing with the same same adolescent in most of these situations, a minor, and but not being able to share information that would be beneficial to both the actions taken by the public bodies, but also to the individual and to that individual's family there. I do have a few people who are going to be speaking to this today. They've been working on trying to resolve some of the questions and issues and concerns that some people have. And there's also a proposal here as part of this, an enactment clause, to have this issue further reviewed through the department, through the Commission on Youth.
Okay.
And with that, I'd be happy to answer any questions.
Senator Deeds.
Senator Barker, I can't seem to pull up the substitute. I just wondered if you could explain the differences between the substitute and this bill.
There's one section, and I could just sort of read it very quickly, that's on lines 27 through 37 on the substitute, which says that in talking about the parties and the individuals that could access the records through the court system, says, as this is section 6, subsection 6, the Department of Social Services or any local Department of Social Services providing services or care for or has accepted a referral for investigation and provision of services in accordance with this subsection, a juvenile who is a subject of record, and also the Department of Behavioral Health and Developmental Services or local community services boards. And then it goes down, and they have to have agreements with the Department of Juvenile Justice to provide coordinated services to the juveniles who are subject to these records, and to have basically the two entities work together on these types of things. So it's basically giving this Department of Social Services at the local level, and at the local and state level, for that matter, and the community services boards that are working with the juveniles and their families. Giving them access to the court records there.
Mr.
Senator
Chair.
Deeds. Senator Deeds.
An additional question. Why, I think I get that, and that's consistent with some of the other new language, but I wonder why all the new language isn't covered under the existing language where it speaks with representatives of a public or private agency or department providing supervision or having legal custody of the child or furnishing evaluation or treatment of the child ordered or requested by the court. Why wouldn't that include departments of social services?
To tell you the truth, I do not know the answer to that, but I do have people from both Alexandria and Fairfax who have been dealing with these issues that are going to be speaking to that here. So,
okay. Anybody have any further question of the patron? Well, let's go to the public.
Mr. Chairman.
Senator Shervill.
Thank you. I appreciate what we're trying to do here, and I think, however, there's also a sensitivity to giving non-criminal justice-related entities wide open access to juvenile files, which can contain a lot of very sensitive information also relating to the defense of a child. And I noted that at least on lines 34 to 37, it says that if these DSS agencies get access to records, that they shall not disseminate them any further. However, it says they shall not disseminate the records unless they are expressly authorized by law. I was curious as to whether or not the patron or your supporters would be willing to change authorized by law to required by law, so that those records that they otherwise would not have access to would not be they wouldn't pass them along unless they had to, not because they could, which I think is a big difference. Do you have any feedback about that?
I haven't discussed that with the parties that were there, but I understand your concern there, and I do think that required by law would be an appropriate change for that language there on line 37.
Senator, Charles?
I think that that's being indicated as a friendly amendment, so I think
yes.
All right, is there...
I so move that we strike authorized and replace it with required on line 37.
Senator Deeds, you second it? Senator Deeds?
Second.
You second the motion. Any discussion? All in favor of the line amendment, say aye. Aye. All opposed, no. Motion carries. Okay, thank you, Senator Barker.
All right.
Now, anybody else in the public would like to say something? I see a bunch of people there. Raise your hand if you're in favor of it. Sandra, would you like to go first? Are you in favor of it?
Mr. Chairman, members of the committee, good morning. Sandra Carrison, Office of the Executive Secretary, Supreme Court of Virginia. I unfortunately am unable to access the substitute or see it online. I've tried to pull it up on the legislative information website. I would like to clarify the direction that the substitute is taking, because my understanding was that Senator Barker, good morning, the patron was going to move in the direction of amending section 16.1-300 having to do with court services unit records. Is that what the substitute does?
Charles?
Okay, because I'm hearing a discussion about court records,
Right.
and that there was a significant concern about the confidentiality of the court records. So that was, with that clarification, I'm seeing a nod of heads and a raise of thumbs. With that clarification, thank you.
Charles, would you like to explain
There's
that?
no position on the bill.
Charles, would you like to?
Yes, Mr. Chairman. So the original bill was drafted into a different code section, I believe 16.1305, and the substitute is drafted to 16.1300. So the court's concerns, I think, have been at least addressed in the substitute, and that it is drawn to the 16.1300 section, and that's what Senator Barker was talking about.
Mr. Chairman?
Senator
McDougal.
McDougal.
Can she tell us why, or if the Supreme Court believes that under the current statute they cannot share some of this information?
Yeah, Sandra?
Senator McDougal, Mr. Chairman, Senator McDougal, at least I think that's the voice that I heard, Senator McDougal. What my understanding of this language is that what the Department of Social Services, the expansion that is being proposed here, is that the Department of Social Services, when a petition for relief of custody of a child is filed, the court services unit must refer the case to the local Department of Social Services for an investigation. The local department does not generally, in fact, would not yet have custody of the child. And so that's why the current language wouldn't cover that circumstance under 16.1-305, the court records. Instead, what is happening in that circumstance is that the local Department of Social Services is going to go out and investigate the circumstances that have precipitated the filing of a relief of custody petition to see if they can offer services to stabilize the family, to keep the child within the family, and then to bring that investigation forward to the court when the petition is then heard. That is, I believe, the gap that may be, and I haven't actually, that's just my analysis based upon my understanding of the court processes around these statutes and what I believe is being addressed here. As far as what, to the degree that the Department of Behavioral Health and Developmental Services, and the degree to which the Virginia Department of Social Services may be involved in that, I'm not clear, because it would be the local department. But DBHDS and the local CSB, that part of it, I'm afraid that I can't speak to. I'm not sure if it still includes the language having to do with investigating the assessment of complaint alleging abuse or neglect. Is that language still in there?
Charles? Charles?
Mr. Chairman, sorry, I was momentarily distracted. I do not believe the abuse and neglect is in there.
Okay, that was back to DSS, whether the language regarding investigating abuses, complaints alleging abuses or neglect, I was unclear whether that language was still in there.
Okay, do we still have some other people who want to speak in favor? Who would like to speak in favor? Sarah Taylor, I see you with your hand up.
Good morning, Mr. Chair. Sarah Taylor with the City of Alexandria. We're grateful to Senator Barker for bringing this bill forward. We're grateful to everyone who worked with us to really narrowly tailor the language from where it began to where it is today. As was mentioned, this bill is necessary because the current language in code has not been construed by DJJ and court services to permit this interagency information sharing in the past, either without a contract for services or through a court order, even when the local child welfare department has been providing services to the subject youth. And this has been a barrier to an effective, coordinated response to serve these youth and their families in an efficient, collaborative manner. And this change would regard local child welfare agencies as the true and equal partners that they can and should be when engaged with DJJ to provide coordinated services to these particularly vulnerable youth. And we are aware and respectful of your diligent efforts over the years to protect these records. However, these current limits, they limit our abilities to share these records and make it really challenging to serve these kids and their families in an efficient, coordinated, collaborative case management that they really need. And we hope you'll see the value of this limited, narrowly tailored change and support the bill.
Thank you. Tricia Bassing, you have your hand up. Tricia Bassing.
Hi. Hi. Yes, I'm Tricia Bassing. I'm Chief of Child and Family Behavioral Health Services with the City of Alexandria CSB. Thank you very much for moving this along. I'm very much in support of this of 1206. So for the past several years, I've collaborated with my colleagues in child welfare and court service, people with lived experience in our system, legal experts and advocates, and the Georgetown Center for Juvenile Justice Reform to try to improve our system for families that are involved in both juvenile justice and child welfare. We know that these kids are more vulnerable for deeper involvement in the system, homelessness, out-of-home placement, and chronic behavioral health challenges. It's not because they're bad families. It's because our systems are not sufficiently set up to address the layers of trauma they've experienced. And one vital way to stem this tide is to ensure early coordinated care. It's vital, and it'll allow for efficient and effective coordinated assessment while eliminating redundancies.
Okay, thank you. Go ahead.
And just can I say from our perspective from behavioral health, there are times where we're unaware of the involvement, and that if we're new right away, we could support meeting the child and family's behavioral health needs in addition to ensuring the coordinated response. And it also will allow us to have the clinical assessment within the CSU in their work as well. So I could say much more. Thank you for your time.
Thank you very much. Sonia Brown, you have your hand up.
Good morning. My name is Sonia Bennett Brown, and I'm a constituent with lived experience. I am also a grandmother of a young adult community member who is currently incarcerated for the past 15 months, with 24 more months to complete during this pandemic. His conviction as a child and giving him a juvenile record may have been prevented had we shared information about our family, which we expected that the agencies were doing. Excuse my emotional the departments were unable to share the basic information that would have been able to, they would have been able to coordinate services and been able to better service our family, and the outcome may have been different. Okay.
Thank you very much. I appreciate it. Now, Amy Woodard, you have your hand up.
Good morning, Mr. Chair. I'm actually speaking on some concerns to the bill. Is this the time to do that?
Yeah, go ahead.
Mr. Chair, Amy Woolard, Director of Policy with Legal Aid Justice Center. I do just want to start and say I absolutely laud the intentions of everyone supporting this bill and the work that's being done to treat the support needs of these youth. I do have to raise some concerns with opening up these confidentiality statutes once again. You know, the substitute and the code, the original bill addressed have become a kind of Christmas tree of exceptions of opening up these records. The current statute allows for both a judge and family consent to sharing of these records. And I think the more carve-outs we have, we push aside families' ability to control this information and to tailor it I think there are so many of these statutes we have that have different agencies allowed to access different kinds of information and share it. And there aren't a lot of provisions to deal with confidentiality once that information has been shared.
Okay,
And these are the kinds of things that can haunt kids
okay.
for the rest of their lives. And so I appreciate the intent. We do have some concerns.
Okay.
We would appreciate looking at the issue further rather than going forward with the substantive pieces of the bill.
Thank you. One other person I have, Greta Rosen. I can't read the name. Go
Yes.
ahead. 30 seconds.
My name is Greta Rosenzweig, and I'm the Chief of Child Welfare for the Alexandria Department of Community and Human Services, and I'm speaking in support of Senate Bill 1206. We support this bill because it will allow child welfare services and court services units to identify youth who cross over into each of our systems immediately, and will allow us to share information under privacy guidelines so that child welfare and court service units and child behavioral health can develop coordinated and collaborative assessments, service plans, and service deliveries.
Thank you very much. We appreciate it. Is there anybody else who insists on saying anything for or against? If so, state your name and which side you're on. I guess I don't have anybody in the queue. All right, is there a motion?
Can I have Mr. Chairman, one quick question?
Senator Morrissey.
Thank you. To Senator Barker. You may have addressed it, but I went over to local government for a moment. Is there a prohibition in this bill that once the records are inspected by the Department of Social Services, that they cannot be then shared with any other agency?
Yes, there is, and actually we made an amendment to clarify that on one, unless they're expressly required by law.
Okay. Is there a motion? I'm sorry. Is there a motion been made and seconded that the bill be reported? Does it have to go to finance? Yeah, I think no. Doesn't have to go to finance.
I don't think it has.
Okay, all right. Motion's been made that the bill as amended be reported, and it's been seconded. All in favor of the motion to report the bill, vote aye.
Oh, and my.
Ayes 8, no 7.
Ayes 8, no 7. The bill is reported. Thank you.
Thank you.
Senator. All right, Senator Ruff has a bill. Is he here, Senator Ruff? Is he out there? Senator Ruff's 1454, evidence of mental competency, mental scans of brain. Senate Bill 1454. He's not here? Okay. All right, then we'll move on to Senator Morrissey has a couple of bills. If Senator Ruff is here, let us know. Okay, Senator Morrissey, you have two bills. Senate Bill 1262, restricted permit prepayment of fines and costs.
Good morning, Mr. Chair, members of the committees. Let's go 1262 first. Everybody, of course, is familiar with the bill that we did last year that allows individuals to obtain a driver's license even though they have not paid fines and costs. This bill is a close cousin. It eliminates the requirement to prepay all fines and costs by an individual who is eligible to receive a restricted license. Currently in Virginia, the individuals who are eligible to receive a restricted license are required to pay all fines and costs prior to getting that restricted license. We have gone over again and again the burden placed on low-income individuals who want to drive to work, put food on the table, etc. When we passed the bill last year, I hope it would be the pleasure of this body to report this bill.
Okay. Any questions of the patron? Senate Bill 1226.
Mr. Chairman.
Yeah, Senator Norman.
I'd ask the patron if you would consider it a friendly amendment that we just forgive any fines and costs to any defendant that is determined to be indigent.
I would consider that a friendly amendment.
Okay, is there, Charles, you got a line amendment on this?
Mr. Chairman, I'm not offering it, I'm inquiring.
I don't think it's a serious inquiry.
Hold on a second. I'm not. Slow down.
I think it's not a serious inquiry. Okay.
I thought, Mr. Chairman, everything that comes out of the senator from James City's mouth is absolutely dead on serious.
Okay, it's not, no second has been made. Any other questions or anybody from the public would like to say anything about Senate Bill 1226? Okay.
There are a few people from the public.
Okay, 30 seconds each person. Say your name and whether you're for or against it. All in favor of it first. Emmanuel Harris, you like the bill?
Yes, sir. I'm in favor of the bill. Thank you.
Thank you. All right, Brad Lindsay.
Yes, good morning, Mr. Chair. This is Brad Lindsay with Justice for Virginia. We support the legislation.
Okay, anybody else want to say one thing or the other? Okay, looks like it's a popular bill. Okay, Senator Morsi, is there a motion? Been moved and seconded that Senate Bill 1226 be reported and sent to Finance. All in favor of the motion, vote aye. Okay.
Ayes 10, noes 15.
Ayes 10.
No, 5.
10 to 5. What's a little digit? 10 to 5. The bill is passed and reported since Finance. Does it have to go to Finance? Yes. Okay. Yes. Okay. Reported and referred to Finance. Senate Bill 1442. Senator Morsi, Public Defender's Office for the County of Chesterfield.
Yes, sir, Mr. Chairman. Mr. Chairman, this bill amends 19.2-163.04 to create a public defender's office in the County of Chesterfield. As many people in this room know, public defender's offices were first established in the mid-'70s in Virginia, and it has grown to this point to 25 public defender offices serving 54 locations, including some of our largest counties and cities, including Alexandria, Arlington, Fairfax, City of Richmond. Chesterfield County has almost 350,000 citizens. It has its own judicial district. It does not have a public defender's office in there. There are 4 essential reasons that I see in establishing a public defender's office. The first one is specialization. All public defenders are highly specialized, and their entire practice is devoted to criminal defense work. I am not disparaging at all people that take court-appointed work. That is wonderful. They are noble in doing that. However, the public defenders just focus on criminal defense. Second reason is training. Public defender attorneys receive constant and consistent high-quality training specifically designed for criminal defense. A newly hired public defender attends a weeks-long skill training program staffed by experienced public defenders. New attorneys in the public defender office complete a 2-part training program on appellate advocacy. All public defenders attend an annual 2-day public defender conference. This training is not unlike what Commonwealth attorneys' offices go through. Each public defender is also tasked with overseeing an in-house training program to provide regular additional training. The third reason is supervision. Each public defender's office has a chief public defender and an additional supervising attorneys. These attorneys provide mentoring, supervision, performance management, and support. Importantly, each public defender office has a designated appellate supervisor that will help the attorneys in appellate matters. And the fourth component is resources. Public defenders' offices are staffed with investigators. They do both fact investigation for the public defenders, and they interview witnesses, and each office has at least one mitigation specialist that helps in sentencing. So for all of those reasons, we need a public defender's office in Chesterfield County.
Does this have to go to finance?
Beg your pardon?
It would have to go to finance, okay.
Yes, sir.
All right, anybody would like to speak for the bill?
Mr. Chairman.
Yeah, Senator Searle.
Thank you, Mr. Chairman. So, I've been having some conversations with the Indigent Defense Council about sort of what their budgeting priorities are, and they said to me that a public defender's office in Chesterfield County is one of their top 2 priorities of things they'd like to see done. So I think this is a good idea. It's needed. It's one of the largest jurisdictions that still doesn't have one. I think we ought to do this. So I move to report the bill.
I think the bill's in good shape. Anybody from the public want to say anything?
Mr. Chairman, a question.
Senator Norman.
I would ask the patron, if this public defender's office is created, will they be defending Senator Chase?
That's not a serious question. Okay. Is it somebody?
Mr. Chairman,
Maria,
Mr. Chairman, I amend my motion to report to be referred to finance, not just report.
Maria, would you like to say something briefly? You in favor of it or not? You're again. Go ahead, speak. Maria.
Thank you, Mr. Chair, members of the committee. I just signed up to answer any questions.
Okay,
Maria
all right.
Jankowski, Virginia Indigent Defense Commission. I don't need to speak.
Okay, it's been moved and seconded that the bill be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 12, noes 3.
Ayes 12, noes 3. The bill is reported and re-referred to finance. Is Senator Ruff here? If not, okay. All right, Senator Ruff's not here. I'll go ahead and present Senate Bill 1443, the minimum mandatory sentencing bill, and then later, and after that, Senate Bill 1261, the Court of Appeals bill. And Senator Deeds.
Senator Edwards.
Yes. Yeah, I'm going to turn. That's what I said. Senator Deeds will take the chair.
Thanks. Okay.
First of all, Mr. Chair, Senate Bill 1443, known as the minimum mandatory sentencing bill, this was a recommendation of the Crime Commission. There's been a major one change that's very important. That is those felonies classified as Class 1 felonies are not in the bill, meaning those Class 1 felonies deal with the death penalty. Right now it's death or life minimum mandatory. They're not in the bill, which means that will remain the same. This bill does not deal with changing anything with regard to Class 1 felonies.
Does that, Mr. Chair, does that require an amendment, or is that in the bill before us?
That's the substitute. I move the substitute.
Second.
Okay, motion and a second on the substitute. All in favor, say aye.
Aye.
Opposed? Okay, is the substitute available to us on?
I can see it, Mr. Chair.
Okay.
It's supposed to be available. The ones that are no longer in the bill and remain the same, they're called Class 1 felonies, willful and deliberate, killing of abduction, somebody after you've abducted somebody, killing a person for hire, and importantly, willful killing of a law enforcement officer for the purpose of interfering with the performance of the official duties. This remains the same. Life, minimum mandatory, or death. Of course, we have a separate bill on death. So other than that, every other category where the code provides for minimum mandatory sentencing is taken out. And the reason for this is we have sentencing guidelines. They're very good. The judges and juries typically follow the sentencing guidelines. The minimum mandatory is very problematic. the General Assembly should not be in the business of sending down minimum mandatory sentences in other cases. And the Supreme Court has historically said sentencing should be involved with two things. One is the nature and history of the defendant, and the nature and extent of the crime. And so I'd like to I'd be glad to answer any questions. Senator Stewart, do you have a question? Anybody have any?
Mr. Chairman. Thank you, Mr. Chairman. Senator Edwards, was this bill looked at by the Crime Commission?
Yes, it was. It was recommended by the Crime Commission.
All right, thank you.
Mr. Chairman.
Senator McDougal.
Mr. Chairman, I'd like to point out that there's no bipartisanness to the Crime Commission, certainly from the Senate. So certainly Senator Servell might have looked at it on the Crime Commission, but nobody else from with an opposing view would have looked at it. But Senator Edwards, does this include eliminating mandatory minimums for a DUI with elevated blood alcohol content?
Yes, it does. And again, you have a judge and jury, and we have sentencing guidelines on that to deal with the issues.
Mr. Chairman.
Senator McDougal.
So this also would eliminate the mandatory minimums for somebody who committed 3 DUI offenses within a period of 5 years.
That's correct. And again, we have judges and sentencing guidelines to deal with these issues.
Mr. Chairman.
Senator Norman.
I'm sure it was just a slip of the tongue. A DUI with an elevated BAC that currently requires a minimum mandatory jail time is not subject to guidelines. I've tried thousands of them, and never once have I seen a guideline used on a misdemeanor on a BAC elevated.
I think there are only guidelines on felony offenses. Is that, perhaps on a third offense DUI, they may have developed some guidelines by now.
Mr. Chairman.
Senator Servell.
Senator Edwards, wouldn't it be correct to say that if we pass this bill, there will be sentencing guidelines on DUI thirds going forward?
I would expect they will be.
Mr. Chairman.
Yes.
Senator McDougal.
Mr. Chairman, but I think to Senator Norman's point, if you have a elevated blood alcohol content and it's a misdemeanor and it's your second offense and you hit somebody, then there's no guidelines in district court or in circuit court if it's appealed. But Mr. Chairman, I have another question for Senator Edwards.
Yes. Senator McDougal.
Does this also include elimination of mandatory minimums if you've committed a violent felony like murder and now are in the public and possess a firearm?
Well, like I say, Class 1 felonies are not in the bill, so.
Mr. Chairman.
Senator McDougal.
I didn't ask about a Class 1 felony. I asked about possession of a firearm after having been convicted of a violent felony. Are we eliminating the mandatory penalty for that offense?
Yes, but we have guidelines.
Mr. Chairman.
Senator Servell.
I would ask Senator Edwards that isn't it correct that if we were to pass this bill, that a sentence that's greater than the mandatory minimum would always be available to a judge to issue if a judge felt that the circumstances of the crime and the nature of the victim and the person's prior history merited such a sentence?
That's why we have judges to look at the nature of and history of the defendant and the nature and extent of the crime. And we have guidelines along those lines as well. That's why we have judges.
Mr. Chairman.
Senator Morrissey.
Thank you. I would say I understand the theme that Senator McDougal was getting at, that some offenses require strict, harsh, or maybe the harshest penalties. But that doesn't prevent the judge, similar to what Senator Servell said a moment ago, from doing just that. If there is a third offense DUI, if it's elevated, if it is a defendant who commits an aggravated felony with a gun, the judge certainly has the resources and tools and authority to impose that strict, severe sentence. All this does is essentially say we're going to give the judges the discretion that the Constitution places in them. That's all it does.
Mr. Chairman.
Isn't that so? That's so.
Yeah.
Senator McDougal.
Mr. Chairman, I remind Senator Morrissey that certainly at one point in time, Richmond City had one of the highest murder rates in the country. One of the ways that that was effectively dealt with was an item called Project Exile, which was mandatory sentences if you had been convicted of a violent felony offense and you possessed a firearm, you knew you were going to the penitentiary for 5 years. And so it was pretty straightforward. So those things that helped take the murder rate from being one of the highest in the country, now we're just getting rid of. So I do think it's a philosophical different view, but this is really concerning.
Mr. Chairman?
Mr. Chairman. Senator Morrissey.
Project Exile was a federal program that took Virginia residents into federal court and locked them up for a set period of time. This legislation from Senator Edwards has no impact and doesn't tell the federal government or the federal judiciary what to do at all.
Mr. Chairman.
Senator Norman.
I would ask the patron, would you accept it as a friendly amendment to include as an exclusion under your bill the possession of a firearm after having been convicted of a violent felony? In other words, a minimum mandatory would remain.
I don't believe so.
Mr. Chairman, is that I don't believe so, or I'm thinking about it?
We already have sentencing guidelines, and these people get locked up as it is, my understanding.
And so if I can understand, Senator Norman, your possession of a firearm while committing a violent felony is already an additional offense. Your suggestion is that it remain a minimum. You maintain a minimum mandatory sentence. Even if you don't, you still have that additional offense.
Mr. Chairman.
Senator Servo.
I'm pretty sure there's a lot of people that want to have something to say about this online. I don't know if we're going to get the public comment, but
There are. And for that reason, we're going to restrict to 5 minutes aside for the pros and 5 minutes for the cons. But unless there are additional questions from the committee, Charles?
Just before you get to public comment, there's one additional thing the substitute does. That is the introduced bill had a provision regarding the resentencing of people previously convicted of a crime that had a mandatory minimum punishment. The substitute eliminates those provisions and has a work group which would be convened by the Secretary of Public Safety, study the feasibility of resentencing. And the work group is in an enactment clause at the end of the substitute on lines 961 to 975. And as I previously mentioned, the substitute eliminates the resentencing provisions.
Mr. Chairman.
Senator Servo.
Thank you, Mr. Chairman. I want to commend the patron on that, even though that was approved by the Crime Commission. I was very concerned about that because there was very little discussion about what that would cost or what that would do for victims, and implementing that would have been very hard. And I think having a work group look at that again is an excellent idea, so I commend him on that.
That's in the substitute as an enactment clause.
Okay, why don't we open it up to public comment? As I said, 5 minutes aside.
Would those who are in favor of the bill please raise their hand in Zoom? There should be a button there to raise your hand. Andy Elders, you can please go ahead.
Hi, good morning. I'm here with Justice Ford, Virginia. We're here in favor of the bill. I think there's going to be a lot of people who are going to talk about the sentencing side of mandatory sentencing. Obviously, it's an important aspect of why this bill should pass. The current law literally it prohibits the exercise of mercy, and that's something we shouldn't do. But I want to make sure that there's also discussion of the effect that sentencing has on someone pre-trial and before they're tried and whether they're deciding whether to plead guilty. Sentencing policy reverberates throughout the criminal justice system. And I have seen many clients, and our offices have seen many clients charged with mandatory minimum offenses. It affects what kind of plea negotiations they get and how they can leverage in those negotiations. It affects whether or not they can truly exercise their right to trial. We talk about how terrible certain offenses are and say that they need mandatory punishment because of the nature of the offenses. But if you're charged with one of those offenses and are not guilty, then you need every opportunity to be able to say, I didn't do it and I want my trial. And when you're faced with mandatory 5, 10, 20 years or a mandatory life sentence, your ability to say, I didn't do it is compromised. We need to abolish all mandatory minimum sentences, including for serious offenses. And I thank you for taking up the bill.
Thank you, Mr. Elders. Who's next?
Emmanuel Harris, please go ahead.
Thank you so much. We strongly support this bill. Mandatory minimums have never made the community safer. Anyone who would argue that Richmond was safer because of mandatory minimums is just misinformed. It's community policing, it's community engagement, it's community enactment. All mandatory minimums has done is pull mothers and fathers out the home, often for drug offenses. So we strongly support this bill. Thank you.
Thank you, sir. Who's next?
Denise Gabrielle, please go ahead.
Wait, the public comment.
Thank you, Mr. Chair. My name is Tensei Gabriel, and I'm with FAM. FAM strongly supports SB 1443. Years of data and research show that mandatory minimums do not reduce or deter crime. Criminologists have long made it clear that it's the certainty of being caught and punished quickly and not the severity of the mandatory sentence that deters crime. And I also just want to emphasize here that repealing mandatory sentences does not mean people go without accountability. What it means is that judges who are selected by the General Assembly and who are informed by guidelines would be able to consider all relevant facts and circumstances about a case before they impose an appropriate sentence instead of a one-size-fits-all punishment. And I also want to emphasize here that repealing mandatory minimums would address racial disparities in sentencing. Black Virginians are most impacted by mandatory minimums. And I just want to say thank you for the opportunity to speak. And I encourage everybody to vote in favor of SB 1443. Thank you.
Thank you. Who's next?
Jonathan Iglesias, please go ahead.
Yes, good morning, Mr. Chairman and members of the committee. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support this bill. As an organization, we've opposed the use of mandatory minimums since the early 90s. The belief then and now is that these are not a real solution that protects victims of sexual and domestic violence. In fact, they're costly and simplistic. They serve to remove judicial discretion, force judges to hand down sentences for survivors who fight back against their abusers. Currently, during the pandemic, we are seeing happen far more often. And this disproportionately impacts Black and Brown communities while providing little real safety for victims or true accountability for offenders. We ask that you pass this bill.
Okay, thank you very much. Who's next?
Gayleen Canoton.
Yes, my name is Gayleen Canoton. I'm the Virginia State Conference NAACP Political Action Chair, and we are strongly in favor for this bill. And for the sake of time, we agree with everyone else. And this is also on a national level a priority as well. Thank you.
Thank you very much, Gayleen. Who's next?
Sheba Williams, please go ahead.
Good morning. My name is Sheba Williams. I'm the Executive Director of No Left Turns. Mandatory minimums fuel our mass incarceration system at a tune of $60 billion per year. If we break that down into families, we incarcerate 60,000 people annually. This has never been about justice. Please repeal mandatory minimums for all of our sakes. Thank you.
Thank you very much. Who's next?
Juanita Belton.
Hi, good morning. My name is Juanita Belton. I'm 1/3 of Sisters in Prison Reform, and we absolutely agree with repealing mandatory minimums. Like everyone else has said, it disproportionately affects Black and Brown communities. It doesn't allow for judges to have discretion, which is what's necessary. And as well, it allows prosecutors to basically coerce defendants into taking plea deals that they otherwise would not take if these mandatory minimums were not there. So we absolutely agree with this bill. Thank you.
Thank you very much. Who's next?
Would those who are in favor of the bill please raise their hand in Zoom? Karen Morrison, please go.
Hi, my name is Karen Morrison. I'm the founder of Fighting for Freedom. We are in favor of replacing all mandatory minimums on the basis that they lead to excessive sentencing. And we are asking that you please leave in the word retroactive so that people that are serving long time in prison, like 70 years to life, that they have the opportunity to be resentenced. So please do not take out retroactive in the bill. Thank you.
Thank you very much. Who's next?
Lori House, please go ahead.
Good morning.
Mr. Chairman and members of the committee, this is Lori Haas with the Coalition to Stop Gun Violence and the Educational Fund to Stop Gun Violence. We support the bill.
Okay, thank you very much. Who's next?
Would those who are in support of the bill please raise their hand in Zoom? Sean Juanita?
Time is up, so if you just identify yourself, and if you're with a group, that's fine.
Thank you, Mr. Chair. Sean Winero, Legislative Liaison with the Humanization Project. We strongly support the bill.
Okay, who's next?
There's no deterrent value. Thank you.
Dominique Martin, please go ahead.
Good afternoon. Dominique Martin, New Virginia Majority, and we support the bill for all the
Okay,
reasons.
thank you very much. Who's next?
Hi, this is Darlene Wells. I'm a constituent of Virginia with a family member serving mandatory life for a nonviolent drug charge. We absolutely support this bill.
Okay, thank you very much. Is there anybody else? Okay, people that have a contrary view now have the same 5 minutes.
Those who would speak against the bill, please raise your hand in Zoom. Camelia Cooper, please go.
No, Camille Cooper.
Camille Cooper, you were muted. Please unmute.
Sorry, can you hear me now?
Yeah. Yes.
Okay. My name is Camille Cooper. We are opposed to just the elimination of the mandatory minimums related to the optional mandatory minimums on sex offenses. I'm looking at current incarceration data for Virginia, and if you look at just the top offenses for production of child pornography, distribution of child pornography, solicitation, and forcible rape of a child under 13, you will see that the racial disparities that exist on drug offenses and property crimes do not exist in the numbers related to these offenses. The majority of them are white. Between 83 and 100% of those offenders convicted under the mandatory minimums for child pornography and rape and object sexual penetration of a child under 13 are white. So while I am 100% with you that you do need to eliminate many of the mandatory minimums that disproportionately impact communities of color, the few sex offenses that have mandatory minimums on them in Virginia, you don't see those same type of racial disparities. Also, what we know about sex offenders is that they don't have just one victim. In the most recent study, 40% of sex offenders had between 2 and 15 victims each. So I would disagree with comments around whether the mandatory minimums are in fact a good public safety tool, because it will impact future victims. For those reasons, we would ask you to remove the retroactivity clause on sex offenses and carve out mandatory minimums on sex offenses from the bill. Thank you.
Okay, thank you very much. Who's next?
John Jones, please go ahead.
Thank you, Mr. Chairman. I'm John Jones, representing the Virginia Sheriff's Association and its more than 9,000 members. We're opposed to removing the mandatory minimums, especially for assault and malicious assault on law enforcement officers. We believe that Senate Bill 1443 sends the wrong message to the men and women that serve each day protecting Virginia's citizens and their communities, while these deputies are performing vital public safety services in law enforcement, jail, and courts. The deputies face more challenges than ever. Reducing penalties for these crimes will have meaning to those that commit those assaults on their officers. We have all seen how words matter. We think this bill will matter by saying that it's not as serious as it used to be to assault a law enforcement officer. Keep in mind, Mr. Chairman and members of the committee, it is a minimum mandatory, not a maximum mandatory, so that still leaves room for discretion by the court. Thank you so much for hearing me.
Thank you so much. Who's next?
Wayne Huggins.
Good morning, Mr. Chairman. Wayne Huggins, representing the Virginia State Police Association. First, I want to thank the chairman, Chairman Edwards, for considering our request to eliminate Class 1 felonies, particularly that of capital murder of a police officer. We very much appreciate that. We would like to ask for one additional consideration, and that's assault on a police officer, as Mr. Jones needs the public support. So again, Thank you for eliminating the Class 1 felony and ask for your additional consideration on assault on a police officer. Thank you.
Thank you very much. Who's next?
Colin Drappert, please go ahead.
Good morning, Mr. Chair. Colin Draper with the Crime Commission. I'm not offering any comment, just here to assist with any questions.
Okay, thank you, Colin. Who's next?
Those who are against the bill, please raise their hand in Zoom. Mr. Chair, there are no hands raised at this time.
Okay,
Mr. Chairman?
Senator Sasslaw had something. It was answered. Okay.
Mr. Chairman?
I have a question.
Morrissey.
There was one proponent. Could she have 30 seconds? I wanted to hear her comments. It's Andre Hakes. I think she's from Fluvanna or Charlottesville, who was a proponent of the bill. Could we hear from her?
Andre Hakes, please go ahead.
I'm Andre Hakes. I am president-elect of the Virginia Association of Criminal Defense Lawyers. The VACDL supports Senate Bill 1443, in particular because we should trust judges to be judges. The legislature put them on the bench. They're in the courtroom. They know the case and the parties best. This is also a separation of powers issue. We have sentencing guidelines already, and many prosecutors stack mandatory minimums to create a large trial penalty. For those reasons, VACDL supports this bill, and thank you, Senator Morrissey.
Thank you, ma'am. Senator Peterson.
Yes, sir. I have a question. And I don't practice criminal defense, 98% of my practice is civil. But here's the question I have, and that is this bill retroactive? In other words, people that were sentenced. I'm seeing people shake their heads no.
Senator Peterson, I think that one of the things Charles explained, there was a provision in this bill that allowed people to be resentenced, but that was taken out in the substitute. And the enactment clause that Charles spoke to creates a work group that'll take a look at whether or not there should be some retroactivity added in the future.
Okay, that's good, because I've had people that are watching this discussion texting me, asking me about that, so that's now been answered. Thanks.
Okay. Mr. Chairman?
Senator Morrissey.
And I would also tell Senator Peterson that we have situations where defendants are not only overcharged, but prosecutors will hit them with 5, 6 cases where there's a mandatory minimum 5 years each. And let me tell you, there is simply a chilling effect on their right to take a jury trial. They cave.
Mr. Chairman.
Senator Surville.
Thank you. I'm going to speak to the bill. So there's about, I think, 7 or 10 different reasons why we need to do this. Number one, mandatory minimum sentences don't work. I think you heard one of the advocates, I can't remember her name, but she pointed out that all the studies have shown that the certainty of getting caught is a lot more important in terms of deterring crime than a mandatory minimum sentence. In my experience, most of the people who I represent who end up getting caught up in mandatory minimum sentence had no idea there was even a mandatory minimum sentence on the books for such things, number one. Number two, in the 24 years I've been practicing law, these things have proliferated like crazy, especially on low-level crimes like DUI, which is a serious crime, but also assault and battery. For a while, we had people hanging ornaments on that tree, like for hospital workers and lots of other people. The only effect that I've noticed on that is it drives up attorney's fees. Well, that's great for me. It's not. It's horrible policy. It used to be the case when I started practicing law that somebody would come in with a high BAC DUI, they'd pay a minimal flat fee, you'd work out a deal, you'd plead them guilty, work out a deal. Now, with mandatory jail time, people pay a lot of money to stay out of jail. And the only thing it's succeeded in doing is clogging up the courts. I would note that these things catch up low-income people a lot. In my experience, they force people who have legitimate defenses to plead guilty to offenses a lot. So you see a lot of people, I think, wrongfully convicted because of these. I would note that juries are not informed of a mandatory minimum sentence before they assess guilt or innocence, which I think is a significant problem. It just definitely impairs the right to trial by jury. I would note that with regard to the sex offenses, we heard some comments about that. The data shows that sex offenders are much less likely to reoffend than other people. And so I think the public safety issue on that, I think, has probably not been well fleshed out today at all. The last thing I would say, Mr. Chairman, is that there's a group that did a financial analysis of the effect of mandatory minimums. It's called Recidivism, and they estimated that by eliminating mandatory minimum sentences, the taxpayers would save $80 million over 5 years, and people would regain 2,400 life years back because of the effect these things have on outcomes. And Mr. Chairman, I think this is a bill that we desperately need to move along, and I would move that we report it and re-refer it to Finance.
Chairman. Let me see if there's a second on that motion. And
Second.
And that, okay, then Senator Norman.
Mr. Chairman, sometimes I inadvertently agree with what Senator Servell says. This is not one of those occasions. You talk about minimum mandatories, and I would dispute what he has suggested about sex offenders, particularly those who are pedophiles. There is a very, very important ingredient in minimum mandatories on pedophiles and like sex offenders. It incapacitates them and removes them from society for a period of time. Does that mean that rehabilitates them? No, but it minimizes the exposure, and I suggest the representation about the number of victims that a pedophile has between 2 and 15 is pretty accurate.
Senator Sasslaw.
How much time would it take to amend this bill to take care of the situation that he and the lady that testified in opposition of the bill?
Well, I don't know, but I would suggest that this bill still has to go to Finance, and it's a long way from being finished. Even if it passes out of here, there'll be an opportunity to do some more work to it in Finance.
I agree, Mr. Chairman, and I do have a thought or two at the appropriate time to offer that amendment.
So we have a motion that's been motion to report and re-refer to Finance. It's been seconded. Is there further discussion? Are there further motions? If not, please open the roll.
Ayes 9, no 6.
Ayes 9, no 6. The bill goes to Finance. Before we get to the other bill, Senator Edwards, I think Senator McDougal has a motion on Senate Bill 1454 from Senator Ruff.
Thank you, Mr. Chairman. I've talked with Senator Ruff and expressed to him the concerns that many of us have about this bill. And after going through that, I told him I was going to make a motion to gently PBI the 1454.
Motion and a second. Is there further discussion, or are there other motions? If not, please open the roll.
Ayes 15, no 0.
That bill is done for. Senator Edwards, you've got another bill.
Okay, thank you. This will be the last bill for the day. Senate Bill 1261.
Mr. Chairman.
Senator Servell.
Can we get the substitute in front of everybody? Because it's pretty long, and they probably ought to start looking at it while...
I'd move that the substitute be adopted.
Second.
And that substitute's available on LIS now. Okay, there's a motion and a second to adopt the substitute. All in favor, say aye.
Aye.
Okay, opposed? Okay, the substitute's before you, Senator Edwards.
All right, Mr. Chairman, members of the committee, last September, the Judicial Council issued a report in connection with a study of the jurisdiction of the Court of Appeals, SJ 47. I believe Senator Shorville may have put that resolution in 2018. And the Judicial Council met in December and recommended unanimously that the Court of Appeals bill be adopted and put into law. What this does is the following. First of all, every state in the entire country, but Virginia, has an appeal of right in both civil cases and in criminal cases. Let me repeat that. Virginia is the only state in the country that does not have an appeal of right in all civil and all criminal cases. The bar associations throughout the state, the business groups throughout the state have unanimously supported an appeal of right. It's universally recognized that the model for justice should have at least one appeal of right in all civil and all criminal cases. From Aristotle in 200 BC to the American Bar Association, they've supported this concept. The expansion of the court
would be from 11 judges now to 17 judges. Virginia has fewer Court of Appeals judges than any state in our same population base. For example, New Jersey has 37 judges in the Court of Appeals. It has 8.8 million people. We have in Virginia 8.5 million people. We have 11 judges, 37 in New Jersey, 11 in Virginia. Washington State has 22 judges. They're smaller than Virginia, 7.6 million people. Arizona has 22 Court of Appeals judges. They have 7.2 million people, smaller than Virginia. Massachusetts has 23 judges, and they're smaller than Virginia, 6.8 million people. So we have the smallest Court of Appeals of any state that's similar to us in population. The current situation is, if you want to appeal a civil case, you bypass the Court of Appeals, you go directly to the Supreme Court of Virginia, and then you have to argue a case before a writ panel of 3 judges. If you get denied, you don't get appeal. In the criminal cases, you go directly to the Court of Appeals of Virginia, and there you have to argue a case before 1 judge. And if that judge turns you down, you can appeal that 1 judge to a 3-judge panel, and it's only an appeal of whether or not you should take it. They would grant you the right to appeal the case. If they grant the right, then you got to file another brief and hear the case before a panel of 3 judges. What this does, the limitations in appealing in Virginia, both in criminal and civil cases, means that the trial judges make the final decision as a practical matter. And it's very important that Virginia at least give everybody in civil cases and in criminal cases an absolute right of appeal to a court that will actually hear your case. Some changes in the current law are as follows. The appendix. The appendix can be dispensed with if the attorneys wish to. You could file a truncated record or an appendix. In addition, every criminal case will have a transcript from the clerk's office of the circuit court, and the decision of the Court of Appeals has to be in writing, 3-judge panel. Recently, we looked at the issue, and this was somewhat contentious in the work group, and it had to do with whether or not you're entitled to oral argument. A lot of people want to have absolute oral argument. The Supreme Court pushed back a little bit because they get all these criminal appeals from prisoners, pro se appeals from prisoners that are not meritorious. And so we came up with this. We finally made the final decision last night. If you want to look at page 44, and it says as follows. The Supreme Court can have rules for the Court of Appeals that says that prescribe procedures. 1, authorizing the Court of Appeals to prescribe truncated record or appendix preparation, and 2, permitting the Court of Appeals to dispense with oral argument if the panel has examined the briefs and record and unanimously agrees the oral argument is unnecessary because A, the appeal is wholly without merit, or B, the dispositive issues have been authoritatively decided and the appellant has not argued that the case law, existing case law, should be overturned, extended, modified, or reversed. Let me repeat this. Or you will get oral argument unless the Supreme Court looks at the briefs carefully, Court of Appeals rules, looks at the briefs carefully, and says the appeal is without merit or the dispositive issues have been authoritatively decided previously, and the appellant has not argued that the case law, the existing case law, should be overturned, extended, modified, or reversed. This will happen in very few cases. So as a practical matter, you'll have an absolute right of appeal. There were some other issues that were put in there. We got rid of those. The Fourth Circuit standards, 3 standards of the Fourth Circuit, we didn't adopt that at all. So I think it's important that people understand you will most likely get an oral argument unless your case is wholly without merit or you do not, the case law has been authoritatively decided in the past, and that you're not asking that the case law, existing case law, be overturned, extended, modified, or reversed. That's a very important part of this bill. When it comes to the Attorney General, the Attorney General will get involved when you file a petition for appeal in a criminal case, and the Attorney General will have the right to oversee the appeal, whether working with the Commonwealth's attorney's offices. And the 17 judges that will appoint, the General Assembly should consider regional diversity in the election of judges to the Court of Appeals. I think that's an important issue. I'll be glad to answer any further questions.
Senator Edwards.
Mr.
Senator Norman. Two questions. The first one's probably easier than the other. I saw the language about the Attorney General can file a notice of appearance on the criminal cases, which is a new approach. Have the Commonwealth attorneys expressed an opinion on that one way or the other?
As you well know, the Commonwealth attorneys in some cases, like pretrial motions, can appeal to the Court of Appeals themselves in those cases.
Mr. Chairman, I'd say I understand the process. My question very directly was, has the Commonwealth Attorneys Association expressed an opinion on that new language?
And I don't know what the answer to that, Mr. Chair, is.
This went through 2 years of study.
Has the Commonwealth Attorneys Association been involved in that study?
I assume so. I don't really know.
Mr. Chairman.
Mr. Chairman, I will talk to the Commonwealth Attorneys Association. I don't need another representation.
Do you have another question?
I do.
Okay.
Under the current system of appeals that we have what's referred to as some procedural default provisions. And those procedural default provisions can be fatal to the appeal. Mr. Chairman, my question is, has Senate Bill 1261, as before us, eliminated any procedural default provisions?
Mr.
Yes, somebody.
And by procedural default provisions, you mean if you miss a deadline or you don't get your petition filed in time?
Yes, sir.
Okay. Senator Servell, are you prepared to answer that?
Yeah, that's what I was just trying to find. I know,
Mr. Chairman, I'm interested in what the patron has to say. He's the one that's got the bill.
Well,
this was an issue that we worked on, and it's my understanding we did something along the lines of letting people know, hey, you're default. You got so many days to correct the matter. And I'm not sure how the word ended up.
Is that correct, Senator Servell?
I remember seeing that in one prior draft. I'm trying to find it in this one right now, and it's obviously 70-some pages, and I'm trying to locate it.
The bill is only 101 pages.
101 pages.
I've memorized every word.
Mr. Chairman.
Mr. Chairman and Senator Servo, that's not in this version of the draft.
So there's no procedural default that's no longer the law as a result of this bill, or would no longer be a part of the law?
Mr. Chair, I think the correct way to answer the question is procedural defaults are still available to the court. It is just that the parties would be able to argue whether or not a procedural default is applicable to the case. So in other words, and this is my understanding of current practice, is that the court can issue an opinion on the case dismissing a case under a procedural default, such as an insufficient assignment of error, without having oral argument on this. Because the way the bill is constructed, unless the appeal is without merit or that has been conclusively determined by a prior case, hasn't provided the position of overturning or objecting to that particular case, the parties would get argument before the court, and the parties would be free to argue whether or not there is a procedural default. And the court could dismiss that case because of a procedural default, but there would be argument on it.
Mr. Chairman,
Steve.
Before Steve speaks up, would you be so kind to send me an email directing me to that explicit language that is now in those 101 pages as it relates to procedural default?
Charles, can you point to that language?
You don't have
Yes,
to.
Mr.
You
Chair.
don't have to do it right now. Just let me know in the next day or so.
The bill, if it gets out of here, it'll have to go to finance.
Yes, sir.
What happened here?
Senator Obenshain.
Mr. Chairman, a couple of questions. Number one, why is there no fiscal impact statement for this bill?
I will say the governor has put in some money.
Can you tell us how much money? And I know that's not the purview of this committee, but
I don't know, Senator. I don't know. I don't have that information, but I know the governor did pay for this in the budget. That's why there's no fiscal impact. I'm not sure how much. If anybody has that answer for Senator Obenshain.
Mr. Chairman,
Senator Servell, do you have that answer?
my recollection is the governor put in about $4 million, and that was premised on expanding the court by 4. This bill expands it by 6. And I believe under the cost estimates that are on the last page of the study, that would necessitate an additional $1 million. I would also just note that the Attorney General's office has estimated that that this would require them to add about 50 plus or minus additional assistant attorneys general.
50.
I believe so, and I put in a budget amendment to cover that. But the exact number, if you assume their calculations are correct, are also partly a function of whether or not you include exactly whether or not the AG takes over, at what stage the AG takes over the appeal, or whether you continue the existing process we have where a Commonwealth attorney is allowed to participate in the appeal all the way through.
So, Mr. Chairman,
Senator Obenshain.
so that 4 new justices or judges of the Court of Appeals are in the budget, not the additional 2 called for this in this bill, nor are the 50 assistant attorney generals.
I think that's right.
Senator Peterson.
Mr. Chairman,
Senator
I'm sorry.
Obenshain, I apologize.
That's all right. A couple of other questions for the patron. Number 2, you've heard the adage, justice delayed is justice denied. I have a civil case in which we tried it last December. We filed a petition for appeal. The petition was not granted until November of this past year, and my guess is it won't be fully resolved until May or June. That'll be 18 months. Is this going to add another 18 months to the process for civil cases?
Mr. Chairman.
Mr.
Mr. Chairman.
I don't know.
Not if we add the additional judges, we should
Mr. Chairman.
do it in a timely fashion.
Anything in the bill that will ensure that cases aren't dragged out for another 18 months?
Mr. Chairman.
I think Senator Servell wants to supplement the chairman's answers.
Mr. Chairman, I think, first of all, the Court of Appeals right now today endeavors to resolve every case within a year, and in my experience, that typically happens unless, at least in my cases, it's become a problem because I'm stuck here. But if I wasn't here asking for continuances, my cases would be resolved in a year. That's been my experience, and that's their objective. Their current caseload is about 140 cases per judge. The American Bar Association recommends, I think, 120 a judge, and the staffing numbers that we have based this proposal on are trying to get it down to 120 cases per judge using the case projections that the study group came up with. And of course, nobody can predict exactly how many cases we're actually going to see because this is all new. But if you assume that the projections that the study work group came up with are accurate, we should actually have a lower case volume per judge by about 20 cases per judge if we were to do this and fund it the way we've asked. And so that actually should reduce the amount of time for appeal from 12 months down to maybe 10, I guess. I don't know. Somebody at the Court of Appeals might be able to answer that better. But if we don't fund this well enough, right, if we don't give them the full slate of judges they need with the policy assumptions in this bill, then it could extend.
Senator Obenshain, are you done?
Mr. Chairman, I think the number is 120 has to do with the opinions they actually write every year. All right?
All right.
Cases per judge, not opinions, cases.
All right.
And final,
Mr. Chair.
The queue is Senator Peterson, then Senator Norman, but Senator Obenshain's not done yet.
Yeah, final question is, I see in the original bill that the appeal of right for criminal cases is to the defendant. but that the Commonwealth doesn't have an appeal of right. In civil cases, both plaintiffs and defendants have an appeal of right. Why is it that the Commonwealth wouldn't have an appeal of right?
Well, there's such thing as double jeopardy, Senator.
Well, obviously, it is limited by appealable issues, but there are appealable issues that the Commonwealth is allowed to petition the court. In your bill, it says that they can petition the court, but on those issues, there is not an appeal of right. So I'm asking, on properly appealable issues, why wouldn't you give the Commonwealth an appeal of right as well?
Well,
Mr. Chairman.
Senator Peterson. Next.
The question, maybe.
Yep. My question, Peterson.
Did I get an...
There's a question.
Senator Serval can answer your question.
All right.
Mr. Chairman, I think the word petition is more semantic than meaning. The Commonwealth Attorney, we're not changing anything about the Commonwealth Attorney's current ability to appeal cases in this bill, but we called it a petition for appeal instead of an appeal, because I think there were some other reasons why we had to distinguish within the bill. But I mean, Charles can probably correct me if I'm wrong, but this bill will not change current practice, and in fact, it will guarantee the Commonwealth just as much a right to have their case heard as they have today. So I don't really think Charles can probably answer it better than I can, but I remember we had a little bit of discussion about it.
Mr. Chairman, I understand that, but we are expanding the right of a defendant to have their appeals heard. So why wouldn't we adopt a commensurate change in the right of the Commonwealth to have its appeals heard?
Mr. Chair, Charles.
Thank you, Mr. Chairman. Let me just so everybody understands what the current practice is. If you're a defendant, you've been convicted, you have to petition for an appeal. You get to go to one judge. If that judge denies your petition, then you can ask for an oral argument before 3 to get authority, and then if they grant you to the appeal, then you get your appeal, right? I don't believe that if the Commonwealth appeals today, I don't believe the Commonwealth has to go through that same process, and maybe Charles can correct me if I'm wrong, but I've never had...
The Commonwealth does not have to go through that process.
Right, and so this bill doesn't change that. This bill guarantees the Commonwealth a 3-judge panel just like they get today.
And Mr. Chair,
add something.
I think we kept that language just out of ease because the CA, the Commonwealth Attorney, is the one who institutes the appeal, and they are the ones who would be potentially arguing the Commonwealth's appeal versus the defendant appeal, where it's switching entirely over to mostly entirely over to the Attorney General. So it was just easier to keep the language remaining the same. It doesn't change anything that the current Commonwealth Attorney can do. And that's why it was purely, I'll say, ease of drafting to keep the language consistent with the current practice.
Well, if it's to make life easier for you, Charles, I'm for it.
Okay, well then, Senator Peterson.
Okay.
That was a joke. I'm kidding.
Yeah, I understand.
All right. This is Peterson. I've got a question similar along the lines on the finality issue that Senator Obenchain raised. And just as background, I do Supreme Court appeals all the time. I've probably done 50 oral arguments in my career. And I've done no Court of Appeals because I don't do criminal and divorce. My question is that if you have to go through the Court of Appeals before you get to the Supreme Court, does that mean you have to argue before the Court of Appeals, that appeal's granted, then you got to petition for a writ, you go in front of a writ panel? I mean, are we expediting this at all?
No. Mr. Chairman.
Senator Edwards.
The answer is you're giving everybody a right of review.
I'm not
and criminal. Yes, after the Court of Appeals, and we haven't changed the system when you appeal to the Supreme Court from the Court of Appeals, you go to a writ panel. That has not changed.
Okay, because I got to be honest, my interest in a right of review really directly depends on whether or not I won or lost at the trial court. But
you always win, don't you?
No, I don't. Here's my question, though, and that is, if you're the appellant, you're the person that's pursuing the appeal, it sounds like you're adding, I know it's great to get an appeal of right, I understand that, but particularly if it's an interlocutory issue, if it's an injunction, if it's a place where you need immediate relief, I mean, how many layers are we adding to the system? You know, I've had interlocutory appeals, and one advantage of the system right now is I can get in front of the Supreme Court within weeks if I have to. Are we still going to have that ability?
Mr. Chairman? Yeah, we had specific discussions with, I would say, some of the top appellate lawyers in the state about interlocutory and injunctions, and
I noticed you didn't call me, by the way.
But we had discussions with them, and yes, you're going to be able to get immediate review on these things in the Court of Appeals. I would also just note that by providing the Court of Appeals to look at every single case, it's going to, I think, reduce the volume at the Supreme Court and make actually the Supreme Court will go faster because they're going to have fewer cases to look at.
But here's the problem. I appreciate you keep referring back to the Court of Appeals, but let's say, for example, an injunction is entered against my client without notice, and I appeal that immediately, and now I have to go to Court of Appeals, and maybe they agree with me, but now I got to go up to the Supreme Court. In other words, if time is of the essence, how do I get in front of the Supreme Court so I can get a final ruling?
Let me go ahead. Senator Edwards or Senator Servo?
Mr. Chairman, first of all, you got two different concepts here: interlocutory and injunction. But assuming, for the sake of argument, you have an injunction and you appeal it, or somebody else appeals it. Somebody appeals it. Right. It goes to the Court of Appeals. The Court of Appeals. What?
Let's say they reverse it or vacate it.
Then you have the right to appeal it to do a petition for appeal to the Supreme Court and ask them for relief, just like you would today.
Let me try to explain one thing. Right now, what we've done is this: turn the Court of Appeals into error correcting, like the Supreme Court does in civil cases, as well as criminal cases. Error correcting at the Court of Appeals. The Supreme Court would be more of a policy-making court. Not every case gets to be heard in the Supreme Court, not unlike the federal system.
Okay, all right.
Mr. Chairman?
Let me make one last point, and then I'll be quiet.
I would suggest the patron look at lines 147 to 175 if you're concerned about injunctions.
Let me make one more practical point, and that is, for those of us that practice in the Supreme Court, there's a specific set of rules we've been following since I took Virginia procedure as a law student. This is going to take effect July 1, 2021. And there's a lot of lawyers out there that are going to be affected by this. How are we going to promulgate these rules? How are we going to let people know that we have a whole new system going on?
The bill will go to the Supreme Court will have, and the Court of Appeals will have to October to get the rules done. They ask for additional time. It will be effective in October, but the judges can go into effect July 1 because the Supreme Court would like to get the judges in place even before the bill goes into effect.
Senator Norman.
Mr. Chairman, this editorial comment is probably a more appropriate venue once this bill is referred. But once again, while the advocates of this bill believe it is a wonderful policy, once again, it is absolutely devoid of the fiscal implications. We heard the other day that in the current budget, excluding these additional AGs, was over 340 new full-time positions. And now, as a result of changing this, we're saying we need 50 more assistant attorney generals. At some point, there's got to be a connection.
Senator Norman, I would say that's an appropriate discussion when we get to the Finance Committee with this bill. Are there further questions for the patron? Is there public comment? Is there a significant amount of public comment?
Mr. Chair, there is public comment.
There are a bunch of people? Let's do 3 minutes aside.
Andy Elders, please go ahead.
Thank you. Good morning again. Andy Elders with Justice Forward, Virginia. I just want to stress in terms of the criminal cases that we see in the system, how important it is to have review available in every case. This is a common law jurisdiction. Every case not only ensures that we protect the rights of individual litigants and individual accused in the system, it also helps to create, establish, and ensure the legitimacy of the rule of law. So to the extent that we have error by our trial courts and that error goes unreviewed, that means that the common law is not working, that we're not using each case to build law for future cases. So it's really important that we expand the rule of law, that we expand access to ensure the rule of law. Obviously, beyond that, there are always concerns about ensuring that every party has access to the courts and to meaningful review. And we thank you for the bill, and we ask that the committee vote to report it.
Thank you very much. Who's next?
Alice Armstrong, please go ahead.
Thank you, Mr. Chairman. Alice Armstrong. I'm the Chief Staff Attorney for the Court of Appeals of Virginia. We wanted to thank the Chair for the funding that has already been included, and we did submit a fiscal impact statement. We also appreciate the opportunity to have additional time to get staff on board and get our systems retooled, and I'm available to answer technical questions.
You were available. You were part of the study.
Correct.
Okay. Thank you very much. Are there additional folks who want to speak in favor?
Jeff Palmore, please go ahead.
Good morning, Mr. Chairman, members of the committee. Jeff Palmore, on behalf of the Virginia Bar Association, we participated in the study and support expanded access to justice and support the expanded right of appeal in civil cases. And I can also share that the Virginia Chamber of Commerce also supports expanding the right of appeal in civil cases to the Court of Appeals. Thank you all very much.
Thank you very much. Who's next?
Lori Lord, please go ahead.
Thank you very much. Lori Lord, Chief Staff Attorney at the Supreme Court of Virginia. I too am here simply to answer any technical questions the committee might have. Thank you so much.
Thank you very much. Who's next?
I got a question for this young.
Okay, if we halt the timer. Senator Peterson's got a question.
Yeah, my question is, are you all going to have more cases at the Supreme Court? Forget the Court of Appeals. At the Supreme Court, if we pass this, are you going to have more cases, less cases, more opinions, less opinions? How's this going to impact your caseload? Because to date, you all are the one-stop shop for people in my business, which is civil or commercial practitioners.
Yes, sir, I understand. That, of course, is the basis of conjecture in one part, but I do think the removal of the jurisdictional barrier for custody cases, domestic relations cases, all the traffic cases in 17-410 will create an increase in cases in our court. Petitions. But why am I? Yes, sir. But it might be offset by as someone has said, a drop in civil cases. Once someone gets a result from the Court of Appeals, they may or may not wish to pursue that to the next level. But on the other hand, we will have expanded jurisdiction as well from the cases that now, most of which are final in the Court of Appeals. Again, the big one being domestic relations. About 350 of these cases are filed each year in the Court of Appeals. In the last few years, 30 of them in the past couple of years have come to the Supreme Court having to demonstrate matters of significant presidential value or a determinative constitutional issue. So like I say, where on one side we may have fewer civil cases that come up, on the other hand, we might get, particularly on the front end, the petition for appeal and more civil cases. Yes, sir.
Does that answer your question, Senator Peterson?
Mr. Chairman.
Senator Servell.
Thank you. I have a question for the Supreme Court person. So I'm looking at the study right now, and isn't it true that according to the data in the study that in 2000 the Supreme Court had 1,500 cases appealed to it, but as of today it's dropped to 600. I mean, the Supreme Court has basically been seeing a lot fewer cases than it historically has, and it's been accepting a lot fewer than it historically has. Isn't that true?
I am not familiar with those numbers. I'm more familiar with the 1,700 to 1,800 case range. I'm not sure if your numbers include original jurisdiction filings, which of course would continue even in this new regime, the Supreme Court will maintain original jurisdiction over habeas, et cetera, and those have been averaging about 500 a year. So the numbers I'm more familiar with are closer to 17 to 1,800, sir.
Mr. Chairman,
Senator Surville.
I'm looking at the numbers of the petitions of appeal from the Court of Appeals to the Supreme Court, number one. But number two, with regard to the cases of original jurisdiction you just described, isn't it true that all those cases are now going to get filtered out by the Court of Appeals? The Court of Appeals is going to deal with all those and resolve a lot of them so that the Supreme Court will never see them.
No, sir. The original jurisdiction cases are a matter of that's a constitutional provision. All the habeas cases, writs of mandamus, writs of prohibition, those are not affected by this legislation.
Mr. Chairman.
Senator Surville.
Question for the patron. Senator Edwards, isn't it true that we changed those provisions and all these habeas cases and the ones you just described are all going to go to the Court of Appeals instead of the Supreme Court now?
That's correct. That's my understanding.
Mr. Chairman,
Do you like
we didn't
that
change
answer
those.
better than the Supreme Court's answer?
Yeah. Ask enough until you get the right answer. Kristen, do you have something you want to add?
We couldn't change in this bill anything that is constitutionally provided for to go to the Supreme Court. So habeas, SCC cases, and writs of prohibition and mandamus couldn't be changed in this bill without a constitutional amendment.
Are there other speakers who want to speak in favor of this legislation?
Catherine Zagurski, please go ahead.
Okay, start the timer again, please.
Good morning. This is Catherine French-Zagorski. I'm Chief Appellate Counsel with the Virginia Indigent Defense Council. I just want to quickly add that while we were really concerned about the limitations for the right to oral argument with criminal defendants, because currently criminal defendants have a right to oral argument under the current system, that we are okay with the current changes. Thank you.
Thank you very much. Are there others?
Stacy Davenport, please go ahead.
Yes, this is Jim Hingley using Stacy Davenport's connection. I'm the Commonwealth's attorney for Albemarle County, and I'm speaking on behalf of the Virginia Association of Commonwealth's Attorneys. We had an objection to the bill. The objection has been resolved in the substitute, so we have no comment.
Okay, thank you very much for that clarification. Are there others?
No, Mr. Chair, no other hands are raised at this time.
Okay, are there those with an opposite point of view?
There are no hands raised at this time.
Okay, the bill is before the committee. Are there additional questions or comments?
Move to report and refer to finance.
Mr. Chairman, it's Steve Benjamin.
Steve Benjamin, yes.
Senator Benjamin.
I only wanted
Senator
to make
Benjamin.
I only wanted to make one comment in the event that it is useful to any member of the committee. What this bill does not do is expand appellate access in criminal cases. It does not provide for further argument or make the Court of Appeals more accessible in any way in criminal cases. That's just an observation.
That doesn't it give the criminal defendant a right of appeal? You don't have to argue a writ anymore. You get the right to an appeal to the Court of Appeals?
Mr. Chairman, to answer your question, that's more of a semantical point. Under current law, every criminal defendant has a right to petition for an appeal. It is first reviewed by a single judge. If that judge denies the petition for appeal, then the defendant has a right to argue before a three-judge panel. That three-judge panel, just like the one-judge review, will produce a written opinion. And so although it is considered a petition stage, nevertheless, it is essentially the same as a merit review. This does away with that petition stage, but it still only provides for one argument, whereas a criminal defendant currently would have at least that one argument, if not more, if the petition were granted. So to say that it gives a criminal defendant an automatic right to appeal, he has that already. It's just that it's called a petition for an appeal. It may blossom into a merits argument.
Senator Obenshane.
So, Mr. Benjamin,
it's huge. This is huge.
So, given that the petition is a right of appeal in that it is judicially heard, judicially decided. You would agree, would you not, that in every civil case in the Commonwealth of Virginia, there already now exists a right of appeal?
Mr. Chairman, Senator Obenshain, you're asking the wrong person about civil cases, but I think that currently civil cases only have that right to petition for appeal to the Virginia Supreme Court.
Yes, but that is an appeal as you described in Court of Appeals, correct?
Mr. Chair.
It is. And Mr. Chairman, Senator Obenshain, the question would be, and I don't know, whether a party petitioning in a civil case to the Virginia Supreme Court receives a written opinion, as we do in the Court of Appeals on petition in criminal
Chair,
cases.
No. Yeah, let me speak. I mean, with all due respect to Mr. Benjamin, he's swimming way outside his lane here. The short answer is you do not get an opinion at the writ stage in the Supreme Court on civil cases.
Well, that's what I said.
Right.
No, that's what I said.
Okay. And
I think you get a one-sentence denial.
Let me make a couple points, because, again, I speak from someone that, this is, for lack of a better term, what I do for a living. So there's parts I really like about this bill. I like the appeal of right aspect on criminal cases. Okay, we need to have that. All criminal cases need to be reviewed on the merits. And again, that's not my bailiwick, but I like that very much. I also like the expansion of more judges in the Court of Appeals. More judges means a more in-depth review. I like that point very much. What I do not like is taking what is right now a pretty good system for adjudicating civil cases and now dropping it down into the Court of Appeals, where you're going to have zero subject matter knowledge about it. Let me give you an example. I do condemnation cases. I represent property owners all over Virginia. When I appear in front of the Supreme Court and I talk about concepts from that very finite piece of law, people know what I'm talking about. If I go in front of the Court of Appeals, there will be nobody on that bench with experience. Nobody.
Mr. Chair.
And let me just finish, please.
I know. Excuse me.
I think there are some good things in this bill, but I think when it comes to civil practice, there's a reason why the Chamber of Commerce loves this bill, Senator Surivel, and your ears should have perked up when you heard that, because you're not going to have finality on your big verdicts for years now, and you may not get to keep them. And I'm going to remind you of that when you come crying to me years later about you lost a verdict in the Court of Appeals or the Supreme Court. I've said enough.
Senator Morrissey has a...
Just one point. With regard to Senator Peterson's comment that now there's going to be another level called the Virginia Court of Appeals for his civil matter, I'm still trying to wrap my head around why he would object to another court, say he loses in circuit court in Fairfax County, why he would object to having a possibility of succeeding in the Court of Appeals, and if he loses there, a possibility of succeeding in the Supreme Court, which is where he has been going directly so far. And I'm going to stop there because I can see he wants to answer that, but I want to finish my comment.
And I will simply quote the words from the Eastern District of Virginia emblazoned over the courthouse: justice delayed is justice denied. And at least in the current system, while it's not perfect, you do get a result. And I just get worried about all of these various appellate courts we're putting in front of civil practitioners that are going to delay the finality of results, especially, like I said, in cases which have a fairly arcane subject matter where the knowledge base is not going to be there on the Court of Appeals.
And the last comment that I want to make, Mr. Chairman, is this. Mr. Benjamin, who I have a great deal of regard for, said it's a matter of semantics. I disagree. Now, if you have a right to appeal a right, you're not going before an individual jurist in the Court of Appeals asking for that your petition be granted. You have a full right to have the Court of Appeals decide your case. Right now, what takes place is if an individual appeals to the Court of Appeals and his writ is denied either by an individual jurist or a panel of three, the person then appeals to the Supreme Court. There's a big difference having a right to appeal and having that Court of Appeals, not an individual or a panel, hear that individual's appeal.
Okay, I think there was a motion to report and refer to finance made by Senator Servell. Was there a second on that motion? Is there further discussion, or are there other motions? If not, please open the roll.
Ayes 8, noes 6, 1 abstention.
Okay, the bill's reported and referred to finance. Was that the last bill?
Yes, sir.
Okay, well then we'll rise.
Mr. Chairman, please, I have
Senator Stanley.
I have an order of business pursuant to a friend, if I may, at this time. Mr. Chairman, I'd make a motion that at this time we nominate to certify Judge O'Barry from the Chesterfield General District Court. She was left off the list last time.
Got a motion and a second.
Mr. Chair.
Senator Morrissey.
Yes, we had an opportunity to do this last time. We voted. She was taken out of the block. We debated. Nobody made a motion to recertify her. That opportunity was made. Mr. Chair, we are revisiting that issue, and if we're going to be doing that, then I want to be able. First of all, we've already gone down that path. But if we are going to debate that, if we are going to go there, I want to be able to argue it, or at least comment on it.
Well, the floor is yours. I think the motion's in order, so the floor is yours, Senator Morrissey.
I'm sorry?
The floor is yours, Senator Morrissey.
Okay. All right. Let's be clear what happened here. We vetted Judge DeBerry on June 11th. December 11th. And when we did that, people in the community, members of the NAACP, in fact, the entire executive committee of the Chesterfield branch of the NAACP expressed no confidence. There were sociologists, court minders, people that sat in the court, people that professors from Virginia State University that gave compelling stories why she wasn't worthy of being certified. One of the most compelling arguments was from a former delegate, Manoli Lapasi, who said the following. And these judicial performance evaluation, JPE, were given to all 47 judges. Judge O'Barry was dead last. 47 out of 47. He then, and those scores were high 70s and low 80s, and that was dead last. And he made the comment, 7 years after being on the bench for 7 years, her scores were in the 30s and 40s. But she's gotten better. She did. After 12 years, she rose to an F-. And then we had probably 15 people, and I call it organic individuals, who did not know each other, that said that from the NAACP to the Christian Crusade from Voters for Attorneys, et cetera, there were 35 attorneys that wrote a letter that said that we were scared to come forward, but they sent a letter enunciating why she wasn't qualified. And then we had a hearing in here. And if that means anything, and if those individuals from those organizations that I just mentioned mean anything, then we don't revisit every time we get pressure from a United States senator or from a congressman or from somebody else to certify that person. So I'll end by saying this. The most compelling letter against certification was her own deputy clerk. Now, let's be clear. Judge O'Barry is an African American. Her clerk was an African American, and her clerk set forth in compelling language that she was the most rude, churlish individual ever on the bench. She didn't respect litigants. She didn't respect defendants. And and she was not, and she could not support her reappointment. The most troubling thing was this. The African American people that testified against her said that she has destroyed African American lives and people of color's lives. She was renowned for denying bail, specifically for black folk. I had never seen in 30 years more people in the African American community come forward asking that an individual not be reappointed. And here we are now, after taking this up, because my friend from Franklin County has gotten pressure from somebody. You're interfering in a judicial district that's not your bailiwick. Chesterfield County has its own judicial district, 350,000 citizens. All three state senators, Senator Chase, Senator Morrissey, Senator Hashmi, do not support certification. And I got to tell you, to my friend, I take umbrage that somebody from outside that jurisdiction, because of some sort of pressure, is now asking that we certify her. And if we go down that path right now, then we will be opening that up to everyone who has every jurisdiction in the state. So I hope the body would vote no.
I'm going to rule that this judges are not on the agenda today. It's out of order, and I move that we adjourned. We're adjourned.